your time, Mr. Clay. It's okay. Mr. Bradley, good morning.
Good morning, Your Honor. May it please the Court, John Bradley for the Commonwealth. This case presents an unusual circumstance wherein a trial judge has allowed an evidentiary hearing based on a defense allegation that the prosecution knowingly presented false testimony to the grand jury in the course of its investigation. The grand jury presentation in this case involved 7 witnesses in total. 6 of those 7 witnesses were civilian witnesses, and 5 of those 6 civilian witnesses testified to admissions made to them by the 2 defendants in this case. 28 years ago, in Commonwealth versus Salmon, this court propounded a standard by which a defendant may be entitled to an evidentiary hearing based on an allegation such as this one. And the standard that this court set was that it was incumbent on a defendant to make a substantial preliminary showing that the Commonwealth knowingly presented false testimony to the grand jury. It's the Commonwealth's position that the judge abused his discretion in allowing an evidentiary hearing in this case. And essentially we're arguing that the defense did not even come remotely close to meeting the standard set forth by this court in Salmon. All the defendants have ever alleged in this case is that we failed to impeach the 6 civilian witnesses with garden variety trial-type impeachment information, some of which I might point out wouldn't even be admissible at trial, such as the mental health history of a particular defendant, such as the fact that a particular defendant was a drug addict for a period of time. These are the types of allegations made by the defendants in this case, and it was on this basis that the judge allowed an evidentiary hearing in this matter. Now, we pursued a 211-3 appeal, obviously, to get here, and I would say that that was our only recourse in this case. Simply put, we had no other mechanism to stop this from happening. And if we had allowed this hearing to continue to the point where the defendants were permitted to call these civilian witnesses at an evidentiary hearing, the Commonwealth felt that we were likely to suffer irreparable harm.
And why is that?
That's because, Your Honor, the key witnesses in this case, the civilian witnesses who testified at the grand jury, were friends and associates of these defendants. 2 of those witnesses were, let me back up a little. We petitioned after the grand jury presentation to the Witness Relocation Board to have 2 of those witnesses relocated because they were in fear of these defendants. One of the witnesses is the named victim in an indictment where the defendant, Mr. Snow, is charged with intimidating a witness, the basis of which was that he attempted to enlist the aid of a soon-to-be-released fellow inmate at a house of correction to burn down her house in retaliation for her testimony at the grand jury. So there were legitimate fears on our part that these witnesses would be subject to further intimidation should they be forced to testify at an evidentiary hearing, and frankly, that they would be so fearful and afraid that they could well change their testimony.
Well, let me ask you, I understand your concerns, but if they did testify and the defendants had an opportunity to cross-examine them, wouldn't that at least give you testimony to your benefit to use at trial? Should they change their testimony before trial, or should they become so threatened that they won't testify, or heaven forbid anything happen to them?
Well, that's certainly a possibility.
So that it might give you some benefit.
That's a possibility, Your Honor, but...
And if they refuse to testify at this proceeding, don't you stand the same possibility that they're not going to testify at trial?
That's possible.
So might you not just as well find out now as then?
Oh, I don't think so, Your Honor. That's the whole purpose in calling them before the grand jury.
But there wasn't the opportunity to cross-examine, so it could not possibly be used later
Well,
if they become unavailable.
Well, it could possibly be used later, Your Honor, depending on, if they become unavailable, you're right.
Yeah, yeah.
But if they choose to testify in a different fashion at trial, then their grand jury testimony could possibly be used. And that's one of the points also that I want to make to the court, is that this court has long expressed a preference for prosecutors to call live witnesses before the grand jury. That's what we did in this case. I think it's the right way to do it. I think the grand jury should hear from fact witnesses, particularly in a murder investigation, and we shouldn't be penalized for it. And in essence, that's what's going on here. We are being penalized by the judge for calling these live witnesses and not impeaching them with the fact that they use drugs, the fact that they have mental health histories, the fact they might have made an inconsistent statement, and that's just not right. That's not what this court had in mind when you propounded the Salmon decision 28 years ago. The Salmon case, I would point out, had an extraordinary set of facts. In that case, it was a single witness, and in reviewing the cases, that's where prosecutors tend to run into trouble on this issue, when they only call a single witness, when they have a police officer, a police detective testify as a conduit of all the information in the investigation. And in Salmon, it was a single witness who flat out got it wrong, at least with respect to a good amount of the information he testified to before the grand jury. Whether he did so knowingly and intentionally was never discovered, but this court said basically, look, we know he was wrong about testifying concerning these identifications. An evidentiary hearing is necessary to find out if he was also wrong with respect to the rest of the information about which he testified. And that's not even close to what we have here. We presented a thorough investigation to this grand jury. They had a chance to see these witnesses up close and personal, to evaluate their credibility. They heard about, frankly, the lifestyles that they led, that they hung around with these defendants, that they used drugs, that they drank alcohol. They knew what they were getting. And the proffer made by the defendants just doesn't even come anywhere near the substantial preliminary showing that we knowingly presented false testimony to the grand jury.
So is the alleged abuse of discretion here the calling of the evidentiary hearing, or the calling for an evidentiary hearing in these particular circumstances with these particular two civilian witnesses who may be at risk?
I would go with the broader approach, Your Honor, that the discretion was abused in even allowing an evidentiary hearing. Now, I should point out that obviously we did not pursue an appeal right away from that ruling. We did not appeal until the judge came out and said, well, I'm going to allow a phase 2 of this hearing in which the defendants will be permitted to call civilian witnesses. And that's simply because I didn't think it was, I didn't see the risk of harm by allowing law enforcement witnesses to testify. I didn't think a 211.3 was appropriate at that point because...
So, 4 law enforcement officers testified. You didn't object?
I don't want to say I did object, Your Honor. I objected from the get-go, but I didn't appeal. And it was only at the point where the judge permitted the civilians to testify that we pursued this appeal.
Am I correct?
So the civilians haven't yet testified?
That's correct.
Now, let's assume that you're here under 211.3, correctly under 211.3. We're looking, at the single justice's decision. We have to, it's sort of like a double abuse of discretion.
Right.
In what respect do you think the single justice erred?
The single justice, with all due respect, I don't think the single justice really got the full flavor of what this appeal was all about. The single justice faulted the Commonwealth for, first, not pursuing an appeal right away, that is, when the judge allowed the hearing in the first instance. But, the way I see it, Your Honor, I shouldn't be penalized for not running up here the very second I felt aggrieved. 211.3...
Oh, but this is not just some free-floating evidentiary hearing. This is an evidentiary hearing on a motion to dismiss, and I'm just reading from the single justice's decision, given that the police officers have testified. In other words, it's sort of like we can go halfway through the evidentiary hearing, but not the whole way. It's inappropriate and highly unfair to grant the Commonwealth the relief it seeks at this point, leaving the evidentiary record on the motion to dismiss with only the testimony from the police and the parole witnesses. I mean, isn't that... I'm not saying that you should run up here all of the time, but you must surely have known that they would call the civilian witnesses.
I never thought the judge would allow it, Your Honor. I thought the judge was simply being careful by allowing them to get that far. I think by allowing the defendants to call the law enforcement witnesses, they received a windfall to which they were not entitled. So I think the single justice is looking at it through the wrong lens. It's not that it's unfair to the defendants to stop this hearing halfway. Under the Salmon standard, they got more than they were entitled to.
Am I correct that an evidentiary hearing on a motion to dismiss of this type is quite unusual?
Extremely unusual.
I don't recall one, but
I've never seen it in 18 years that I've been a prosecutor. And Salmon's 28 years old. Salmon was decided in 1982. And
usually just decided on the transcript of the grand jury.
That's right. It's usually either a McCarthy motion based on probable cause or an Odell motion based on some type of misconduct by the prosecutor. But it's almost always decided on the grand jury minutes themselves without any supplementation whatsoever. So this was an extraordinary circumstance here. And unless the court has any additional questions, I would rely on my brief.
Thank you, Mr. Bradley. Mr. Nyman, good morning.
Good morning. May it please the court, my name is Steve Nyman. I represent James Winquist, one of the co-defendants in this case. Just directing this court's attention back to November 9th of last year, in its order, this court stated that it had concerns about otherwise irremediable consequences attached to permitting civilian witnesses to testify, and asked that this case be briefed and set as a threshold why 211(3) relief is appropriate here. And I would submit that the Commonwealth hasn't done it in this case. The standard is really clear that the substantial claims of irremediable error must be presented, and only in exceptional circumstances is this relief to be used, where it becomes necessary to protect substantive rights. The Commonwealth is not losing any substantive rights by Judge Locke having this hearing. I'd also submit to the court that, and Justice Cowan, your question was well pointed, isn't it unusual to have a hearing like this? It absolutely is, but when you take a look at the very, very detailed, thorough motion that Attorney Fitzgerald did on behalf of Mr. Snow that was joined by Mr. Winquist about the Odell and Salmon issues that he thought should be scrutinized by the court, obviously Justice Locke took note and said, this requires a hearing. So this is one of those circumstances where at least the trial judge found that it was absolutely necessary to conduct an inquiry. Well, go a little further. What's not before this court, but what Justice Locke obviously considered, was the testimony of the 4 police officers. And that testimony must have been extremely compelling to him, because if you take a look at the history of this case, he keeps on making defense counsel detail additional reasons why you need the civilian witnesses, and says, well, let me listen to the 4 police officers first, or the 6 police officers first, excuse me, or 5 police officers and a probation officer, and then I'll let you know whether or not I want to hear from the civilians. And obviously, something very, very poignant was in their testimony, because it warranted him.
Well, what is the big issue here? What is the issue that you're claiming that the integrity? Obviously, you're not claiming a McCarthy motion, not enough evidence. You're claiming that the integrity of the grand jury was impaired. In what way?
Well, I think the only thing that this court can rely on right now, because the order's, I think, limited to whatever was before the single justice, is just what was in Attorney Fitzgerald's motion. And that is arguably...
failure to present exculpatory evidence?
Well, that was only one part of it. There was also the issue about, I think it was Michael Alfano, who was one of the witnesses, being interviewed by a police officer detailing in a report that he was under arrest, yet there being absolutely no record of arrest or any criminal charges. So the issue was, well, what kind of consideration was he being given that was not brought to the attention of the grand jury at that particular time? Was he really under arrest or not under arrest? Why was the probation officer present during the course of this interview? It's highly detailed, that and many other instances in Attorney Fitzgerald's affidavits and memorandum of law. And they are, I think, they're all part of the appendix, and there's several of them. There's a memorandum of law, there's a supplemental, and I think there's another one pertaining just to the civilian witnesses, and of course his supporting affidavit. You have to also keep in mind, I would suggest that this really, the Commonwealth's complaint here really underlies what's becoming a trend in the Commonwealth, and that is to embrace and protect every witness that it sees as valuable to a prosecution in a crime of violence. And we're seeing it more and more in the Superior Court on murder cases where you're getting protective orders restricting you from distributing grand jury minutes to your client until a date set prior
I think
to...
not in this case, Mr. Nyman.
No, but I guess my point is it's an underlying trend. The prosecution refers in this particular case to these witnesses as part of the prosecution team. Our case law has said for a long time that's not the case. These are everybody's witnesses. And additionally, when you read through their testimony and look through the grand jury minutes, many of these witnesses are offering very, very favorable information to both defendants. Exculpatory information, information from Michael Alfano that David Courage admitted to committing these crimes. And it goes a lot beyond that. Information from Kelly Burgess that arguably shows that she has accessorial responsibility for this murder either before or after the fact for which she's not been charged. That she is a potential eyewitness to these people either committing or not committing and could possibly serve in some sort of an alibi capacity. These are everyone's witnesses. They should be scrutinized by the judge. He wants to hear what they have to say, and the Commonwealth hasn't shown any irremediable harm by having these people testify.
Thank you, Mr. Nyman. Good morning, Mr. Sinsheimer.
Good morning, Your Honor. May it please the Court, Robert Sinsheimer for Mr. Snow. I'm going to do my level best not to repeat anything Mr. Nyman said if I can help it, because I join everything he said. So forgive me if I'm just a tad disjointed. I'm going to try to be interstitial. It's interesting that the government talks about Salmon as a 21-year-old case and fails to mention Mayfield, which says explicitly that these matters should be looked at on a case-by-case basis. And yet the government is asking you to second-guess a trial judge who has had the opportunity to review this record with exquisite care and has taken a patient and step-by-step approach. The trial judge understood what was really unusual about this case. Someone asked what's unusual about this case. Well, one of the things that's unusual about this case is that the government chose to prosecute someone knowing full well that someone else had confessed to the crime. Now, the government does a good job of allowing us all to think that they know who's right, that the person who confessed to the crime was wrong in his own confession, and that they did nothing to get him to change his story, and that they have got the right people now. And without in any way denigrating their subjective good faith, I suggest respectfully that amounts to institutional, not personal, institutional hubris. The government...
Isn't that a question for juries? I mean, these are the kinds of things that get sorted out at trial.
Of course.
Right.
But it's also the kind of thing when one brings a motion under Mayfield in good faith, a reputable defense attorney who's been on both sides of the table, and says, Judge, I'd like to have an evidentiary hearing, and a judge who's a distinguished jurist looks at the record and says, you know, I'm going to give you one. Because when push comes to shove, all we're really talking about is the questioning of witnesses before a judge in the courts of the Commonwealth of Massachusetts. And what can possibly be wrong with that?
I think you're minimizing the effect on frightened witnesses. You're in court every day. A witness comes to court the first time in her or his life, and it's quite a frightening experience.
And I address that, Your Honor, and I'm not. And in fact, it's something I confront personally every single day. I try never to forget that it's a frightening experience for individuals. Yeah, we are all comfortable, and maybe we do. Well, I understand. Those of us who do it day to day and come into the courts of the Commonwealth. At the same time, when you look at the grant of the hearing here, there was a suggestion, well, the witnesses might be intimidated. And I will concede, in the layperson sense, it's intimidating for a civilian to get on the witness stand. But it's not a substantive problem. And as Your Honor's inquiry to Mr. Bradley very early on suggested, you know, it's got to happen sooner or later. And I understand that was Socratic, and that may have not really been your opinion. It was a question to counsel. But it does have to happen sooner or later. And there's no institutional harm. Understanding that the people are subjectively uncomfortable, there's no institutional harm whatsoever to the Commonwealth to have witnesses questioned in the courts of the Commonwealth. And it's not like a deposition. That's a fine analogy from a capable advocate, but it's not the same thing, and I think you know the difference. I'm not going to belabor it. What I do want to get to, in the very short amount of time I have, is that with all due respect, and particularly for the able advocacy of the prosecution, we shouldn't even be looking at Judge Locke's order. And I understand the fear, well, maybe that's just a technical argument, but I don't think it is. I think if your jurisprudence is to remain consistent, and I say this with utmost respect, you've got to look at Judge Boffin's order. And the standard here is whether she, having the same record that you have, abused her discretion. And she didn't. She looked at this carefully. Her opinion is short. It might not be the full-fledged exposition of salmon that the government would like. It might not say that that there was a detailed exposition of whether or not Judge Locke abused his discretion, but she did not abuse her discretion when she paid attention to this record and said, look, this is not fair to interrupt this hearing halfway through. There was a motion to dismiss. The evidence from this point, to this point, has been 100% that of law enforcement. The defense attorney was asked to make a showing. He made a showing, and the distinguished and capable trial judge says, I want to hear more. And that's all that's happening here. Witnesses, yes, respecting that they are personally uncomfortable. Witnesses are going to take the stand and answer questions, and then the trial judge is going to finish the hearing and make a fair ruling. I see that my time is up, so unless you have additional questions, I would rest on the brief.
Thank you.
Thank you.
Simon.